What if I told you that you can legally cancel a loan even years after signing if the lender failed to disclose your rights and key terms up front? In this video, I'm going to be breaking down how to use federal law to rescind a loan, when it applies, how to use 15 U.S.C. 1635 to your advantage, and the case law that prove it works even against big banks. Now, I've studied consumer law, finance law, Truth in Lending Act, a rescission strategy, and I'm here to show you how to use the law to protect yourself from unlawful contracts. Now, before we dive into it, even though I have that experience studying it, this is not legal advice, okay? I'm not an attorney, okay? After you watch this video, I would make sure you do your due diligence and consult a legal professional, okay? This is only for educational purposes only. Once again, I'm putting this game out here so it's not being gatekept. Okay, I'm doing what any other person can do, which is go and study the information and put my findings online so that you guys can get the interpretations from me. Okay, now, if this is something that you enjoy listening to, make sure to subscribe to the channel. Okay, you subscribe to the channel, then obviously you'll be able to get updates. But also at the same time, we're coming up on 20K subscribers. I believe we're only 100 subscribers away. Go ahead and smash the subscribe button if you haven't already, okay? Number 2, smash the like button, all right? You smash the like button. It's an investment for free. You're literally investing in this type of content so I can keep putting it out there, okay? So the whole purpose of what I'm going to be talking about today is we're going to be talking about what a loan rescission is, what it actually means, okay? We're going to be breaking down 15 U.S.C. 1635. We're also going to be talking about what must be disclosed in order to make a loan valid. We're going to be talking about the case law that backs this up. We're going to be talking about how to rescind a loan step by step, okay? So if you want to gather all of that information, make sure you are staying to the end, okay? Number 2, make sure you have a notebook and a notepad, all right? If you're going to do more research on your own, I would suggest you to make sure you have a notebook and a notepad. All right? If you got a notebook and a notepad, you should be good. Okay? Everything I talk about, don't just take it for face value. Go and research it on your own. If you research it on your own, then you'll have even more clarity coming back to my videos and say, okay, bet this is some key information. But either way, if you just watch this, you just play it in the background, it's still good to listen to because we're going to be diving into some key information that hopefully empowers you to take action on your own. Or if you feel like you want to do this for yourself, this will be the education that will give you more empowerment, but also make you feel more comfortable with the information, because sometimes this stuff online looks confusing, okay? And we just aren't 100% sure that what we're reading is what we are reading. So we're going to break that down. So let's dive into it. The first question that we want to ask is, what is a loan rescission? A loan rescission or a rescission means canceling a contract and restoring both parties to where they were before the agreement. Okay? Understanding how to rescind a loan is super important because it is to an aspect of, under certain conditions, you have a right to rescind a loan if the lender didn't follow proper disclosure rules. So understanding that, looking at this as like a legal eject button, okay? So if you apply for a loan and in some way, shape, or form it was fraudulent, invalid, right? You wasn't properly disclosed, right? It was misrepresented. Information was omitted without your knowledge that was super important to the loan. The Truth in Lending Act essentially requires the truth in lending, gives you the ability to say, hold on, that's not right. And you know what? I'm going to take back that. Okay. And, you know, in this case, we're talking about loans, but you can rescind any contract. Okay. Depending on the terms. All right. Now, let's break down 15 U.S.C. 1635. All right. 15 U.S.C. 1635 talks about the right of rescission as to certain transactions. So it specifically is talking about specific transactions, and we're going to talk about the different types of transaction it's not for, okay? But it doesn't mean that this is an indication that you can use this for other loans as well. Now, it says that except as otherwise provided in this section, in the case of a consumer credit transaction, in opening or increasing the credit limit for an open-ended credit plan in which security interest, including any such interest arising by operational law, is or will be retained or acquired in any property which is used as the principal dwelling, that's the key term, of the person to whom the credit is extended. The obligor shall have the right to rescind the transaction until the midnight of the third business day following the consummation of the transaction or the delivery of the information and the rescission forms required under this section, together with the statement containing the material disclosures required under the subchapter. Okay? Which is later by notifying the creditor in accordance to the regulation of the Bureau of his intention to do so. And the creditor shall clearly and conspicuously disclose in accordance with regulations of the Bureau to any obligor in a transaction subject to this section the rights of the obligor under this section. The creditor shall also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind any transaction subject to this section. Okay? When the obligor exercises right to rescind under the subsection, he is not liable for any finance or other charge, and any security interest given by the obligor, including any such interest arising by the operational law, this is important, becomes void upon rescission. And within 20 days after receipt of the notice of rescission, the creditor shall return the obligor any money or property given as earnest money, down payment, otherwise, and shall take any action necessary to appropriate to reflect the termination of security interest created under the transaction. Okay? If the creditor has delivered any property to the obligor may retain possession of it. Okay? Blase blah. We can continue reading it, but I read through it because it gives a lot of key information and key details. That's, you can read this and you'll say, okay, bet, I totally understand this if you read it. All right. Don't just look at a law and then say, you know what, I'm going to use it, and you haven't really read it. Okay, because it gives clear instruction. You know, there's a couple of people that will reach out to me and say, hey, I want to use this, that, and the third. How do I do it? But I would just refer them back to the law and say, look, the law tells you exactly what to do. Okay, now let's just break this down real quick. Okay, just to simplify it, it says if a loan is secured by your primary residence, you have a right to cancel the loan within 3 business days after, number 1, the transaction is complete, which is the consummation. Number 2, you received all the required disclosures. And number 2, you received 2 copies of a written notice of your right to cancel. If the lender fails to deliver the proper disclosures, the right to rescind is extended to 3 years. Okay? Most borrowers don't realize they can rescind up to 3 years later if the lender never properly disclosed the key terms or cancellation rights. One of the key things that you should get when you get a mortgage, because this is specific for, it says principal dwelling. Okay, so this is very specific to a mortgage. Okay, if we want to play it safe, let's just apply this to a mortgage. If we play this safe and we apply it to a mortgage, it's essentially saying that you should get not only all the disclosures in regards to the transaction, but you should also get a notice to cancel. If you never received a form that says you have 3 days to cancel this, okay, regardless if you get the disclosures, if you go and get a mortgage and you realize, dang, well, I don't know if I want to do this, and you decide to cancel the mortgage, you have 3 days to do it. But because they don't give you this specific notice or even 2 copies of it, of your notice to cancel, because this is them trying to participate fraudulently. They don't want you to cancel it, because if you cancel it, then essentially you really get to keep the property. But I'm not about to say that. That's not legal advice, okay? Because they'll have 20 days to pretty much deliver the money, and if they can't deliver the money, then you get to keep the property. Long story short. But if they took your promissory note and they sold it, as a mortgage-backed security, they wouldn't want to give you these disclosures, okay? And as a matter of fact, they wouldn't even have they wouldn't even be entitled to enforce it. But we're jumping the gun real quick. The whole point is, if they fail to deliver the proper disclosures when you sign this mortgage, then you can rescind it even after 3 years. Okay, so yes, you have 72 hours, but time goes by, you can essentially is open for 3 years. Okay, so we'll talk about what must be disclosed in order to make a loan valid. Okay. Now, if we go straight to the Truth in Lending Act, it talks about, if I go subchapter I, and then I just go straight here, disclosure guidelines. Okay. According to the Truth in Lending Act, number one, they should disclose the APR and the finance charges. Okay. It says here, the determination of the finance charge. Okay. It also talks about the determination of the annual percentage rate. So how they came up with that number. The amount financed. They should also give you a payment schedule. They should give you the total of payments. They also should give you a notice of your right to cancel within 3 days. And as a matter of fact, they're supposed to give you 2 written notices of the right to cancel. So you should get 2 copies of that. If they give you 1 copy but never gave you 2 copies, then essentially they are not really acknowledging this information. Okay, because if anything is missing, misleading, or not properly acknowledged, the loan is ripe for rescission. Okay, so let's just dive into some of the case law that backs this up. Now, the case law that backs this up is Jesinoski versus Countrywide Home Loans Incorporated. Okay. It says that in exactly 3 years after borrowing money to refinance their home mortgage, the Jesinoski sent the lender a letter purporting to rescind the transaction. The lender replied, refusing to acknowledge the rescission's validity. 1 year and 1 day later, the Jesinoskis filed suit seeking a declaration of rescission and damages. The district court entered judgment on the pleadings, concluding that a borrower can exercise the Truth in Lending Act right to rescind under 15 U.S.C. 1635 F only by filing a lawsuit within 3 years of the date the loan was consummated. The Eighth Circuit affirmed. The unanimous Supreme Court reversed. A borrower exercising his right to rescind under the Act need only to provide a written notice to the lender within a 3-year period and does not need to file a suit within that period. Section 1635A, a borrower shall have the right to rescind by notifying the creditor of his intentions to do so. Indicate that the rescission is effected when the borrower notifies the creditor of his intention. The statute says nothing about how that right is exercised and does not state that a rescission is necessarily a consequence of judicial action. Okay? So, breaking this down in layman's terms, the borrower does not have to file a lawsuit in order to rescind a loan. They only need to notify the creditor in writing, according to the rescission period in under 15 U.S.C. 1635. And it also says that specifically from the court, what we want to highlight is that the rescission is effected when the borrower notifies the creditor of his intention to rescind. So when you send your letter to the creditor, that rescission takes effect, whether or not they refuse it or acknowledge it. Okay, if you are within the statutes of limitations to do that, then they have 20 days to deliver the monies. Okay, and if they could, now what we talk about is after the fact, if they decide to keep trying to borrow or foreclose, I mean, you have documentation of you notifying this creditor. Okay, so it confirms that you don't need court permission in order to rescind a loan. It confirms that there's no need to tender the money first. And it also puts out there that your notice equals rescission if valid under the law. Okay, so if it's within 3 days, if it's within 3 years without that proper disclosure, then there's no need to get any type of permission. So before we dive into, we'll talk about that after. Here's how to rescind a loan step by step. Okay, if you got all the way to this part of the video, go ahead and hit the like button. Okay, also subscribe if you're brand new. If you do this, you are putting an investment in me for free. Okay, If you subscribe to me, you're going to get updates and notifications. You know what I mean? So thank you guys for doing that. Take some time to do that right now. Let's hop back into it. So how to rescind a loan step by step. Review your original loan documents. Okay. Step 2, check for missing or incorrect disclosures. When we dive back into the APR, when we dive back into the finance charge, when we dive back into the notice to cancel, 2 copies of it. Okay. If you don't see that, then you want to draft a notice of rescission under 15 U.S.C. 1635. Step 4, mail to the creditor via certified mail. And then step 5, wait for the lender's response. They must return the original note and cancel the security interest. Okay. You should be expecting the note. All right. It shouldn't be a response or of a non-acknowledgement or whatever the case may be. If they don't comply, you have grounds for a lawsuit or FDCPA or Truth in Lending Act violation claim. Okay. You compare the rescission with a conditional acceptance to demand proof of lawful disclosure and funding. So not only do you want to send a letter in regards to 15 U.S.C. 1635, you want to wait for their response before you start to challenge them when they say, oh, it isn't acknowledged. Or as a matter of fact, you can send this with the notice of rescission. Hey, I'll conditionally accept this loan if you can prove that you have actually given me the proper disclosures. Okay. And also at the same time, the funding. All right. So here's the other question that you will ask. Okay. When does the Truth in Lending Act apply and when doesn't it apply? Under 15 U.S.C. 1635, it gives you the right to rescind a loan only if all of the following applies. Number 1, the loan is for personal, family, or household purposes. Okay. So technically it isn't effective when it comes to a business. Number 2, the loan is secured by your principal residence, house, condo, mobile home that you live in. And number 3, the lender didn't properly provide disclosures or the notice of rescission. Okay. Here's some common qualifying loan types: mortgage refinance loans, home equity line of credits, second mortgages, home improvement loans, if secured by the home, and reverse mortgages in some cases. Okay. Here's when the Truth in Lending Act decision does not apply under 15 U.S.C. 1635. So you cannot use notice of rescission for these type of loans. Purchase money mortgages. Use the loan to buy the home. Okay. Number 2, the loan secured by investment properties or vacation homes. Auto loans, student loans, personal loans, and unsecured debt. Okay. What is unsecured debt? Credit cards. Business purpose loans and commercial property. So if you are looking to purchase a home as a rental property and then rescind it, it doesn't work like that. Okay. And credit cards not secured by your home. Okay. Meaning if you didn't use that credit card to do home improvement and things in that nature, then no, it doesn't work. So here's what you can do for other types of loans. Even though the Truth in Lending Act under 15 U.S.C. 1635 may not apply, you can still explore other legal remedies for cancellation and discharge or even invalidation. So even though we can disregard 15 U.S.C. 1635, we can still talk about the aspect of the Truth in Lending Act violation under 15 U.S.C. 1601, which still applies broadly. Okay. So even if 15 U.S.C. 1635 doesn't apply, if the truth in lending disclosures were inaccurate, missing, or deceptive, you can sue for statutory damages. You can sue for actual damages. You can sue for attorney fees, and you can potentially sue for the invalidation of the contract via fraud by inducement. We talked about this yesterday in my previous video. If you want to see that, it's probably going to be up here or in the description. Number 2. Any loan that has fraud or misrepresentation can potentially be challenged or rescinded under common law as regards to a lack of consideration, fraudulent inducement, unconscionable terms, or failure to disclose material facts. If it doesn't meet these requirements, then that contract is invalid and you can potentially discharge or rescind the loan. Okay. If we want to talk about the defenses for negotiable instruments, if we talk about the aspect of UCC 3-305, you have a right to assert defenses like forgery, fraud, unauthorized signatures, or no consideration. So if you go to the fact of them having a lack of consideration, them fraudulently inducing, them giving unconscionable terms, failure to disclose material facts, then you can assert your defense under UCC 3-305, which gives you the ability to defend yourself against negotiable instruments that are forged, fraud, unauthorized, and have no consideration. If they cannot prove that consideration, then essentially you can defend against that. Okay, you can challenge them on that. And you can use UCC 1-308 to preserve your rights if you are pressured to agree. Okay, be very careful with doing that, because sometimes only do this if you really don't want to agree. Okay, if you feel pressured to agree to something, then you dive into UCC 1-308. But be careful, because I've seen many people do this, and what happens is that company usually cancels the loan. Okay, and then they want to fight against, hey, well, I signed it a certain way, and they canceled it. I mean, they can cancel a loan. All right, now if they securitized it and you find out, then you can sue them. Okay. Talking about, you can also go based off the Fair Debt Collection Practices Act violations and the Fair Credit Reporting Act violations. So if a debt collector or a third-party servicer is still trying to collect on the loan, then you can demand validation. You can dispute those inaccurates under your credit report. And you can check for a 1099-C and make sure that they are not double collecting. So if they wrote it off, they cannot collect again. Okay, those laws are 15 U.S.C. 1692G for debt validation, 15 U.S.C. 1681S-2 under the Fair Credit Reporting Act, and then 1099-C. If you look up at 1099-C, you'll be able to see exactly what it does. Anytime something is charged off, the debt is settled and they forfeited their right to collect on the debt. So if it's charged off on your credit report, but there's a debt buyer or collection agency reaching out to you, they really are probably not the holder in due course. Okay. Number 5, state law consumer protection statutes. Most states have unfair and deceptive acts and practices, laws that can be used to challenge shady loan terms or collections even after the Truth in Lending Act. So overall, even while 15 U.S.C. 1635 only applies to a principal dwellings, secured homes, meaning anything that is attached to your home, there are multiple other angles to challenge and possibly cancel different types of loans using the Truth in Lending disclosure violations, common law contract principles, UCC defenses, FDCPA, FCRA enforcement, and state consumer protection laws. Okay, so now that we've gathered all of that, okay, if your lender doesn't play by the rules, it doesn't mean that you're stuck. Challenge them. You have a legal right to cancel a bad loan even years later, and as long as they fail to properly disclose something, you can challenge them on it. Okay, be very keen and be very resourceful in making sure that you have your proper disclosures, making sure you have all your documents and information. If you don't, then start doing the work. Okay, but again, this is not an easy process. This is not a process that you can just get a template, send it off, and boom, you're done. I would just make sure you get very comfortable with the administrative process and the legal process, because again, it's not something that you can just send a template and boom, it'll work. They're going to challenge you. They're going to not acknowledge it. They're going to ignore you. Expect those things to happen. Okay, expect them to not respond. Expect them to give you a hard time. Okay, don't expect them not to do that, because I have a lot of people say, oh, I sent this template out and they ignored me. Well, if you read the law, you know that they cannot just ignore you. Okay, yes, they cannot, but do you know how to properly enforce that? Or are you just going to sit there and say, oh, and cry about it? Okay, or are you going to sit there and call them on the phone and say, y'all ignored me, blah, blah, blah? No, the proper way to do things is always in writing. So if they ignore you, you want to send a notice of dishonor. You want to start to challenge them in court. Okay, it's not that you have to enforce a rescission in court, but if they don't acknowledge your rescission and they don't give you back that notes, then this is when you start to dive into that lawsuit. This is when you want to start challenging them on their consideration, challenging whether they actually loaned you money, challenging the validity of the contract. And this is specific for principal dwelling under 15 U.S.C. 1635. But through the other things that I mentioned, you still have multiple defenses against other types of loans that essentially apply the same exact way. There's the same requirement for other loans as well, okay? There's the same requirement for other types of open-ended credits, okay? So if you understand that, then, you know, it's really all the same, okay? You can really challenge all types of loans and discharge debt and challenge contracts, because it's really a contract battle, the same type of way, okay? Or you're looking for the same type of things. It's based on an honor system, a trust system. So if the company did something that was distrustful, unfair, you have rights to assert. Okay? So now that we got to the end of the video, if you want to learn a little bit more about this, right? You want the templates that I put together in regards to these YouTube videos, tap in with the complete debt guide. It's only 47 bucks. Okay? This is only if you want to learn more, okay? If you are not a person that wants to tap in and read it and write the letters on your own, right? Tap in with the complete debt guide. You can find these templates online, right? Maybe on like a Rocket Lawyer or something like that, but you'll have to pay maybe even the same amount, get a subscription plan or something like that just to get these letters, okay? But it's all going to be included in the complete debt guide. Now, if there's anybody else that is looking to create an additional stream of income, teach people consumer law as well, but also at the same time make money at the same time, then you can use the complete debt guide as an affiliate. You can refer other people. You can create content on consumer law. You can take what you learned from this video and create, content on this, and you can also refer people to the complete debt guide and get 25% profit for each person that you refer to the complete debt guide. Okay. I also include a loan rescission template. I also include a legal notice pack. So if you guys are interested in that, tap into the complete debt guide. Okay. Now, that's specifically for my debt discharge people. Now, if you want to learn how to fix your credit, right, get funding, and then also at the same time start or scale your current business, tap in with my one-on-one mentorship. Now, this is specific for serious people and primarily entrepreneurs that's looking to get business funding. If you're not looking to get business funding, if you're not looking to grow and scale your business, or even looking to just fix your credit, and you're looking to do debt discharge, do not tap into that, or do not put in that application, okay? Because you'll go through a series of questions, you'll watch a free training, and at the end of the day, you'll realize that by the time you get to put in that calendar invite and you get on the phone with me and I tell you, hey, look, well, this conversation is not going to be about debt discharge, you're probably going to be upset, okay? Or your time will be, you'll be wasting my time, you'll be wasting other people's time as well who could have booked that time, okay? This is only for serious candidates only, and trust and believe, I'm not going to get on the phone and teach you everything that I just taught you in this video, okay? Number 3, if you want to learn or just be able to get updates and connect with me on a more consistent basis, tap in on Instagram at biz.nick, okay? Not only do we do credit content, not only do we do consumer law content, not only do you get updates, but I also do motivational, psychological, and mindset content at my other Instagram at The Funded Mind. We are growing on The Funded Mind at this point, so tap in with that. All right. Now, my last question is, have you ever seen missing or shady disclosures in a loan that you signed? Drop your story in the comment section. Remember to like, subscribe, turn on the post notifications so that you get an update, because we are showing you how to flip the system in your favor legally. Remember, again, all my rights are reserved. If you've gotten all the way to the end, make sure to comment the word discharge, and I'll see you in the next one.